I already made the mistakes, Your Honor. It was way before that. After I got put in there for 30.
Here's the problem. You've interfered with the whole system. That's the problem. You should have never done any of this. Dad, don't do it. Court calls case, People versus Cameron Larry.
Good afternoon, Your Honor. Ray Tannehill, Assistant Prosecuting Attorney on behalf.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Larry. Mr. Larry, could you please state your name for the court?
Cameron Larry.
What are we doing?
Your Honor, as I explained at the bench, people are seeking an adjournment. Quite a few things have come up. The evening with the, and I mentioned is that the officer in charge is had informed me at the point that he's ill, cannot be here to testify. We would need his testimony here today. Your Honor, there's also the issue of the jail calls that were made. This defendant, while he was in custody, called the victim multiple times. The content of those calls are highly concerning to the people. They suggest witness tampering. The fact that she is not here today kind of completes the concern we had that his calls and his communication with her have had the effect that he intended them to have. Specifically, we have concerns because he gave her a story of what to come and tell the prosecutor's office. She did comply with that, and as counsel is aware, and courts know where she has indicated to us what I would call a recantation, but certainly a different version of events matching what this defendant instructed her to do. There's a lot more to it, including statements he made, telling people that the victim was not coming to court and so on. With all that, Your Honor, we have concerns, so we need to further look into that. Those calls were shared with the public defenders already. I resent the very specific call to defense counsel this morning. I'm going to be listening to those a little more closely. I'm considering witness tampering charges moving forward. And we do have concerns about this defendant being out of custody and the behavior he might have engaged in and may continue to engage in, and making sure the victim does not appear to testify against.
Mr. Warren.
With respect to the people's adjournment request, at this time, we have no objection to that.
Okay.
And I had an opportunity to speak with my client, Mr. Larry, and Mr. Larry Sr., who is present in court today. Miss Larry was here earlier, and both of his parents really have been calling off work, making every effort to be at all of their sons' court dates.
I recall that the last time he was here, they were here. I recall that. Okay.
And in addition to that, I know back on April 27th, Miss Larry wrote a character letter to the court, which I know the court can't consider at this juncture. However, that was sent to counsel, and I reviewed that. And Miss Larry speaks highly of her son. And I think, you know, insofar as Mr. Larry's at a fork in the road, they are committed to make sure he takes the right path and comes out of this continuing the positive work he was doing before arrest in this case. And I would note that this is Mr. Larry's first interaction with the criminal justice system, as far as I can see on his criminal history. When he was released from custody after spending about 30 days in jail, he was placed on home confinement and lives at home with both of his parents. During the time he was in custody, you know, he had to deal with the consequences of being in custody, which included losing his job. His parents want him to get a new job, and I talked to Mr. Larry about essentially scheduling an interview, talking to his tether agent, and seeing if there can be an accommodation made for him to go and do an interview, which I know, you know, if that needs to be done by stipulation or order, I know it's something that has been accommodated in the past. Mr. Larry's enrolling in school. He's Washtenaw County Community College for either CDL, HVAC licensure, but he's trying to get higher education. And I think since he's been out on home confinement, he's certainly not been violating the court's orders.
Well, but the problem is, I don't know that. That's my great difficulty.
When I talked to Mr. Larry's parents, I was very specific about what the court's orders are, including no contact and what no contact means. They ensured me that they're not going to let it happen under their roof. And as far as he's on home confinement, I mean, what they relayed to me is essentially the court's home confinement tether at this point is he'd be on home confinement anyway. They're making sure that he's staying on the right path. They don't want him to end up in jail or, at the end of this case, to be worse off than he was coming into it. So I'm going to ask the court respectfully to consider continuing his bond at this time. Come back on the next date. I've already talked to Ms. Tana about resolving this case. I'm going to talk to my client at length about resolving this case, which, what we pondered does entail further court supervision. But as far as abiding by the court's orders, Mr. Larry and his parents are going to make sure that continues. So
my difficulty is that I believe that his parents have all the best intentions of the world and are probably the most disappointed by all of this. But I myself am very disappointed when I find as I told you, counsel at the bench, I gave him a huge break the last time in letting him out, knowing that there were phone calls. That's come back in certain respects to bite me because I now know that these weren't just, not to minimize them necessarily, but not just context to the alleged victim saying whatever. He was manipulate the system. I don't even know